Page 2 now, the U.S. Supreme Court and gay marriage. The two finally meet in April. In the meantime, states like Alabama, same-sex couples will have to wait. A federal judge issued a 2-week stay on her ruling that struck down a law that bans gay marriage in Alabama. The state's attorney general is seeking a longer stay until after the Supreme Court rules on the matter. So, the courts are now deciding what the people of dozens of states have already decided against repeatedly.
We're already involved when we're told that we can't have a marriage ceremony that is limited to one man, one woman. We're already involved when a photographer is told that she's going to have to take photos of a same-sex wedding, or a caterer is told she'll have to do a same-sex wedding cake. Look, it's not about the issue of whether you think there should be same-sex marriage or not. It's about, should the individual who doesn't believe that that's appropriate have the freedom to say, no. Here's the point. Could I go into a Jewish delicatessen and order them to make bacon-wrapped shrimp for me? The answer is no. They would say, I'm sorry, we don't do that. Now, if I'm not empowered to force the Jewish kosher delicatessen to make bacon-wrapped shrimp, why should a Christian be forced to participate in something that violates his or her conscience?
Here's the apparent bottom line. The people of today are so much wiser and smarter than the people of 100 years ago, 500 years ago, 1,000 years ago, 4,000 years ago, right? Clearly, that's what the pro-gay marriage lobby is saying. 4,000 years of history defining marriage as a union between a man and a woman is meaningless. They are smarter than everyone, right? But what are the flaws in the argument for gay marriage? Joining me now, attorney and legal analyst Jody Doucette. Jody, it's pretty clear, no matter what side of the argument you're on, in my opinion, that the pro-gay marriage lobby has lost in the court of public opinion, so they're trying to win through the actual court system in this country.
Well, Graham, the reality is that approximately 36 states have permitted same-sex marriage. However, about 14 states are in a state of flux because the law has been challenged in their court. So the Supreme Court is left in a quandary because we have dissension among the states, and that's what the Supreme Court often looks at, as cases where there is dissension among the states. So I think it's a perfect and ripe case for the Supreme Court to decide upon.
Right, but those states that have enacted gay marriage, virtually across the board, the voters have rejected it, so they've found ways to appeal and get this done through the courts, correct?
Well, correct in some sense, but let's take a look at back to the civil rights movement. They had the same scenario, the same history, back when blacks and women couldn't vote, and they had certain requirements, and the states in the South spoke. And was that good enough? That's why we have the Supreme Court to look at equal protection for all the states and for all the people to have the same rights.
But one thing is in the Constitution, your ability to have this vote, and the other is not. There's nothing about gay marriage or anything to do with marriage in the Constitution. That's the difference, right?
Well, no, because the Constitution doesn't spell everything out. What we did have is the Founding Fathers came to this country for freedom, particularly religious freedom and other freedoms that go with that. This has really become also a religious issue for many of the proponents of banning gay marriage. So it's to the very founding principles of why America was created.
But didn't the framers also want us to be a federal system where states have rights? And isn't this a state issue? And building upon that, the framers would want each state to decide for themselves. In other words, California can't impose on Utah its laws, correct?
That's the issue before the Supreme Court, is what do you do when you have marriage that has been sanctioned, permitted, and officiated in one state that permits same-sex marriage, and that same couple travels to another state and can't have the same religious freedoms. It's not an equal protection anymore. They've been treated differently. So that's where the United States, because we are united in our statehood, comes in and says, how does this affect us? And this is where we have to make a ruling where the states can't agree. You have to have the founding principle of our 14th Amendment, equal protection for all, and the right to travel.
Okay, but the 14th Amendment, we don't look at things in a vacuum, do we, in this country? In other words, the 14th Amendment was not put in our Constitution to legalize gay marriage. The 14th Amendment was a post-Civil War amendment to make sure that states treated blacks, that is, former slaves, equally. It has absolutely nothing to do with gay marriage. Would you agree with that?
I don't agree with that. The 14th Amendment was put into place not just for the civil rights movement and blacks. It was put in to have equal protection of everyone, of every race and every kind. And as we know, for example, in California, we have approved through our Constitution that gender is also a constitutionally protected category. So it is clear that oftentimes in the lower union states, we differ from the northern states, and so that's where the Supreme Court sometimes have a dichotomy where they are treated differently. The equal protection is for many different areas of the law, not just for the blacks in the issue.
Do you really believe that in the 1860s, 1870s, when this was ratified, that the people of the time were thinking beyond simply this? You really believe that? That they were going to be able to use, that this country was going to be able to use the, quote, equal protection clause for things other than what they were intending back then?
I think that we look at why everyone came to this country from England. It's very founding principle that we wanted equal protection under many different laws. And I don't understand why there's even an issue where government would fall into people's bedrooms. It's not an issue the government should even have. It should not be before the courts or the state. It should be an individual issue. And the fact that everybody should be equally protected to make their own choices of freedom, I think, is the founding principle that we have based this country on.
Well, I would agree with you. I don't know what the federal government has to do, except when the federal government and state governments get involved in civil unions, then they infuse themselves into marriage. Isn't that correct?
It's correct, and we look back in the civil rights movement that the blacks were not permitted to vote, and because they had all these requirements they had to meet before they would even be approved to be able to vote. And this is akin to that, where you have to have a certain particular type of a belief in your sexuality to be able to be permitted to get a license. The government has no business being in this.
So the government shouldn't be issuing marriage licenses, is basically what you're saying, and leave it up to individual churches and individuals themselves.
I think that we should equate it back to when the right to vote. It needs to be an unequivocal right to vote, as it needs to be an unequivocal right to a license. I ask you this, Charles Manson, a convicted murderer, in jail, he's permitted to have a license to marriage. Why would two law-abiding people not, just because of their sexual preference, which is personal and private?
Well, because it changes the definition of marriage. That is the argument against it, and it changes 4,000 years of history. And once you start redefining marriage, Jody, then you change the whole dynamic. So I could say I'm married to a rock, and then, therefore, I get the protection that I would get from the federal government when and some rights and privileges when you're married. And then the marriage penalty in the IRS form, right? Suddenly I'm married to a rock. That's the problem. You start redefining marriage, there's no limit.
Well, let's look at back not that long ago, Loving versus Virginia did not permit interracial marriages. A license would not be issued if one partner was black and the other partner was white. Doesn't that seem archaic today? If we start saying who's defining marriage? Is it the religious sector that is defining marriage? I think it's an individual choice. The people themselves need to define what they individually and personally believe is marriage.
It's the slippery slope when government gets involved in something like marriage. Jody, thank you.